Hey there, YouTube. I'm just here today. I'd like to talk to those of you who are contemplating divorce, and particularly those of you who find yourselves defendants in no-fault divorces. I think it's important that you know, because your lawyer won't tell you, what the Supreme Court has said about parental rights as fundamental rights in this country. So I'm just going to start reading a few things here. Back in 1944, they said, "It is cardinal with us that the custody, care, and nurture of the child reside first in the parents, whose primary function and freedom include preparation for obligations the state can neither supply nor hinder." Then they said in 1972, "The parent-child relationship is an important interest that undeniably warrants deference and, absent a powerful countervailing interest, protection." In the same case, in the same year, they said, "What is the state interest in separating children from fathers without a hearing designed to determine whether the father is unfit in a particular disputed case? We observe that the state registers no gain towards its declared goals when it separates children from the custody of fit parents. Indeed, if Stanley is a fit father, the state spites its own articulated goals when it needlessly separates him from his family." In 1982, they returned to the subject and said, "If anything, persons faced with forced dissolution of their parental rights have more critical need for procedural protections than do those resisting state intervention into ongoing family affairs." Way back in 1935, they spoke about fundamental rights in general. They said, "The courts must indulge every reasonable presumption against waiver of fundamental constitutional rights and not presume acquiescence in the loss of fundamental rights." And that's kind of the problem in a divorce. When you're the defendant, the court sort of presumes that you have waived your fundamental rights and given them the discretion to interfere with your parental rights as a defendant in a no-fault divorce. Back to the Supreme Court. In 1980, they said, "It is well settled that quite apart from the guarantee of equal protection, if a law impinges upon a fundamental right explicitly or implicitly secured by the Constitution, it is presumptively unconstitutional." And that places a burden of proof on the states. When they seek to interfere with your fundamental rights, they must prove, if you challenge the law, they must overcome the presumption of unconstitutionality and prove that they have a compelling state interest that justifies their interference with your fundamental rights. And the courts don't apply this in divorce court ever. I've never seen it. And finally, it's not actually finally, but it's the only one I have, the last one I have on my list. The case I can't mention because it's not listed here is Troxel v. Granville from 2000, and that is worth looking up and owning a copy and reading it for yourself. But anyway, and I'll cite Troxel v. Granville here on this video in the titles. But anyway, the last thing I have on my list that I can read to you today says this: "Where certain fundamental rights are involved, regulation limiting these rights may be justified only by a compelling state interest, and the legislative enactment must be narrowly tailored to express only legitimate state interests at stake." And again, in divorce court, they don't show a legitimate state interest. They don't ever prove that the no-fault defendant who loses custody and becomes a non-custodial parent, they don't ever prove that he's harming the children or posing any kind of risk, or that the children will suffer if the two parents are allowed to maintain their fundamental parental rights. And the irony here is that, out in the media, liberalism is all over the place telling us about the independence, the separation between a person's marital status and their parental rights. We see books like Heather Has Two Mommies and Strong Mothers, Strong Sons, and Maverick Moms Raising the Next Generation of Exceptional Sons. And all of these books, in one way or another, say that it doesn't matter what your marital status is, you can still be a good parent. And if they're correct, if the liberals are correct, that your parental rights and your family relationship with your children does not depend on your marital status with the other parent, then there is no reason, there is no justification for interfering with anyone's relationship to their children because their other spouse decided they didn't want to be married anymore. And that is something we need to address in our family law. And I hope that by giving you these quotes from the Supreme Court, that you will be able to discuss with your attorney the fact that your parental rights are fundamental and that you do not intend to waive your parental rights just because your spouse has decided to exercise a right to not be married to you. And I wish you the best of luck in your situations, and I hope you can maintain strong and successful family relationships because your kids really need you. Thank you very much.